Hello, my name is Jim Tootin. I'm an associate professor of political science here at Central Virginia Community College. In this video, we'll discuss federalism. Federalism is the allocation of powers and responsibilities among national, state, and local governments and the intergovernmental relations between them. The essence of federalism is that all levels of government in the United States significantly participate in all activities of government. At the same time, each level of government is partially autonomous from the rest. We follow the founders who reserved national government for the legislative, presidential, and judicial branches at the national level, saving federal government for the entity consisting of national, state, and local levels. This chart illustrates how federalism works. Some national powers include the power to coin money, regulate commerce, declare war, raise and maintain an armed forces, and establish a post office. Whereas some state powers include issuing licenses, conducting elections, regulating intrastate commerce or commerce within the state, and providing for public health and safety. Powers shared by both national and state governments are the powers to collect taxes, build roads, borrow money, establish courts, and make and enforce laws. Exclusive powers. The Constitution gives exclusive powers to the national government that states may not exercise. These are foreign relations, the military, war and peace, trade across national and state borders, and the monetary system. States may not make treaties with other countries or with other states, issue money, levy duties on imports or exports, or maintain a standing army or navy, or make war. Concurrent powers. The Constitution accords some powers to the national government without barring them from the states. These concurrent powers include regulating elections, taxing and borrowing money, and establishing courts. National and state governments both regulate commercial activity. In its Commerce Clause, the Constitution gives the national government broad power to regulate commerce with foreign nations and among the several states and with the Indian tribes. The Commerce Clause allows the federal government to establish a national highway system that traverses the states. A state may regulate any and all commerce that is entirely within its borders. National and state governments alike make and enforce laws and choose their own leaders. They have their own constitutions and court systems. A state's Supreme Court decision may be appealed to the U.S. Supreme Court, provided that it raises a federal question, such as an interpretation of the U.S. Constitution or of national law. The Constitution authorizes Congress to enact all laws necessary and proper to execute its enumerated powers. This necessary and proper clause allows the national government to claim implied powers, or logical extensions of the powers explicitly granted to it. For example, national laws can and do outlaw discrimination in employment under Congress's power to regulate interstate commerce. At this point, I would like you to watch a video made by the U.S. Conference on the Judiciary on the 1819 landmark Supreme Court decision in McCulloch v. Maryland. This case and this video explain the application of the necessary and proper clause in defining implied powers retained by the national government. The link can be found below, and there is a link to the video in the course module on federalism. The states existed before the Constitution, so the founders said little about their powers until the 10th Amendment was added in 1791. It holds that powers not delegated to the United States, nor prohibited by it, the Constitution, to the states, are reserved to the states or to the people. States maintain inherent powers that do not conflict with the Constitution. Notably, in the mid-19th century, the Supreme Court recognized that states could exercise police powers to protect the public's health, safety, order, and morals. Reserved powers. Some powers are reserved to the states, such as ratifying proposed amendments to the Constitution and deciding how to elect Congress and the President. National officials are chosen by state elections. Congressional districts are drawn within states. Their boundaries are reset by state officials after the decennial census. So the party that controls a state's legislature and governorship is able to manipulate districts in its favor. Republicans, having taken over many state governments in the 2010 elections, benefited from this opportunity. The Constitution lists responsibilities the national government has to the states. The Constitution cannot be amended to deny the equal representation of each state in the Senate. A state's border cannot be altered without its consent. The national government must guarantee each state a Republican form of government and defend any state upon its request from invasion or domestic upheaval. Article 4 of the Constitution lists responsibilities states have to each other. Each state must give full faith and credit to acts of other states. For instance, a driver's license issued in one state must be recognized as legal and binding by another. No state may deny privileges and immunities to citizens of other states by refusing their fundamental rights. States can, however, deny benefits to out-of-staters if they do not involve fundamental rights. Courts have held that a state may require newly arrived residents to live in a state for a year before being eligible for in-state and thus lower tuition for public universities, but may not force them to wait as long before being able to vote or receive medical care. Officials of one state must extradite persons upon request to another state where they are suspected of a crime. States dispute whether and how to meet these responsibilities. Conflicts are sometimes resolved by national authority. In 2003, several states wanted to try John Muhammad, accused of being the sniper who killed people in and around Washington, D.C. U.S. Attorney General John Ashcroft had to decide which jurisdiction would be first to put him on trial. Ashcroft, the proponent of capital punishment, chose the state with the toughest death penalty law, Virginia. Article 6's Supremacy Clause holds that the Constitution and all national laws are the supreme law of the land. State judges and officials pledge to abide by the U.S. Constitution. In any clash between national laws and state laws, the latter must give way. However, as we shall see, boundaries are often fuzzy between the powers of the national and state governments. Implied powers of the national government and those reserved to the states by the 10th Amendment are unclear and contested. The Constitution leaves much about the relative powers of national and state governments to be shaped by day-to-day politics in which both levels have a strong voice. In one sense, all 50 states are equal. Each has 2 votes in the U.S. Senate. The states also have similar governmental structures to the national government, 3 branches: executive, legislative, and judicial. Only Nebraska has a one-chamber unicameral legislature. Otherwise, the states differ from each other in numerous ways. These include size, diversity of inhabitants, economic development, and levels of education. Differences in population are politically important as they are the basis of each state's number of seats in the House of Representatives over and above the minimum of 1 seat per state. Scholars often refer to 4 different types of federalism. States' rights federalism is an approach to federalism that holds that each state entered into a compact in ratifying the Constitution and can therefore decide whether or not to obey a law it considers unconstitutional. This form of federalism dominated from 1789 until the end of the Civil War. Dual federalism is an approach to federalism that divides power between national and state governments into distinct, clearly demarcated domains of authority. Dual federalism is sometimes referred to as layer cake federalism. This form of federalism was practiced from the end of the Civil War until the New Deal era and the expansion of the national government. Cooperative federalism is an approach to federalism that sees national, state, and local governments working together to address problems and implement public policies in numerous domains. Cooperative federalism is sometimes referred to as marble cake federalism. This form of federalism was introduced during the period beginning with the New Deal era and continuing until the late 1960s. And finally, competitive federalism, an approach to federalism that stresses the conflict and compromise between national, state, and local governments. While one form of federalism may dominate, elements of each of these forms of federalism remain relevant today.